Good afternoon. My name is Hae-sun Kim. Today we will discuss about the Article 16, term of contract under the Labor Standard Act with Labor Attorney Jung Bong-soo. So could you explain specifically about these terms of contract?
Yeah. Hello, how are you today? This is Bong-soo Jung, Korean Labor Attorney. Article 16 of the Labor Standard Act stipulates that employer cannot use a fixed-term employee more than 1 year. Exceptionally, there are no fixed term or some there are business that require certain period of time to complete the project. So in that case, it is exceptional for using the employee more than 1 year. So I think this the Article 16 terminated or dissolved this article. The reason is the replacement law was introduced that is starting July 1st, 2007. The protection law for non-regular workers were introduced. There are two laws. One is fixed-term and short-term contract workers and their protection law. That is, we shortly say Fixed-Term Employment Act. Also, some act regarding protection of dispatched workers. So we call Dispatch Employment Act. So these two laws were introduced. So they have a fixed term for workers. So employee can use those dispatched worker or some fixed-term worker for 2 years as a maximum period. But if they want to use them more than 2 years, then those workers is regarded as there are no fixed term contract period. So that means they will be regarded as the permanent employee. I mean the employee who can work up to retirement age. So this law abolished. I mean, this Article 16 was abolished, but it was replaced by the protection law for non-regular workers.
Yeah. So from 2007, July 1st, the protection law, which was added, I think it was kind of improved, because I think 1 year is rather short for the employee, because when they get used to the work, it's already 1 year. So I think it's a very good improvement. So
yes, so contract period as a fixed term contract was extended to 2 years as a maximum, but after 2 years employer regarded them as a non-fixed term employees. Also there are 2 years fixed term period. There are some exception for if employee uses them more than 2 years, they are regarded as a non-fixed term contract. That means that they become regular employee. But there are some exception for this law. Some those work that require more than to implement a certain project. There are certain periods that require more than 2 years. That is one exception. The other one is those people who need a special protection based on their age, when they get the 55 years, any people who have an employment contract with the employer, in that case, in order to promote aged people, to promote the employment of aged people, so this law is exceptionally excluded. Also, there are 25 professional workers, such as labor attorney, civil attorney, or tax attorney, or the PhD holders who are engaged in such a business. Then those people are exempt from application of this fixed maximum period. Yeah.
So what was the incident that made the turning point of adding this special new article.
Yeah, okay. Thank you
Yeah.
for asking for that issue. So, protection law for non-regular was introduced as of July 1st, 2007. The reason, the background of this establishment of new law was that we had the IMF crisis in 1997. So, to borrow the money from IMF, International Monetary Fund, we had to give up. Also, we had to adopt some flexibility in labor law. That was condition for borrowing money. So, at the time, we introduced two laws. One is dismissal for managerial reason, also dispatched work. So, at the time, because of managerial dismissal, the law. So, because of this law in the Labor Standard Act, many employers fired people due to the managerial reason during the IMF crisis. The foreign currency crisis. So many companies were bankrupt at the time. So, to overcome such a business crisis, it was allowed to fire people. So, after firing people, employer hired people as fixed-term workers. It was it had saved a lot of the labor cost. But employer at the time, they knew using the part-time workers or fixed-term employee would be a very best way to save labor cost. So because of that effect, many employers abused this hiring some temporary workers. So early 2000. In workplace, there are most of people were hired as fixed-term workers. So at the time, lawmakers realized that without special protection, all workers can be used or hired as some temporary workers rather than permanent workers. So at the time, the protection law for non-regular workers introduced. So main some content for this law, there are two things. One is employer cannot hire them more than 2 years. That means they can use temporary workers up to 2 years. Then after that, they must hire them regular workers. But the other one is within 2 years, there should be no discrimination just because of temporary status. So then if there is a discrimination within 2 years period of employment, they can take some remedy claim, like claim for discrimination. And then Labor Commission would deal with some discrimination case. So then they ruled if it is discrimination because of just a non-regular employment position, then there would be a lot of fine. So I think this was turning point when lawmakers introduced this protection law for non-regular workers in 2007. Yeah.
I see. Thank you very much by introducing the specific case. That was very helpful. Thank you.
Okay, thank you for watching. Bye bye.